I'm Michael Levy. I'm an assistant United States attorney in Philadelphia. I'm the now former chief of the computer crime section there, former because I just took semi-retirement status, and they don't allow supervisors to be there only half the time. I'm going to briefly introduce the panel members. If you want to know more about them, everyone's bio is in your program. To my immediate left, Dean Erwin Chemerinsky is the Dean of the University of California Law School at Berkeley. He was the founding Dean of the Law School at the University of California at Irvine. I assume we have a lot of law students here. You've probably read things he's written, so he probably needs very little introduction. Danielle Citron, you probably all know because you've had classes with her. She's also very important today because she's one of the people who made this thing happen and is possible. Britton Heller is the Director of Technology and Society at the Anti-Defamation League. She's had personal experience being victimized by bad behavior on the internet, and unlike a lot of people, was willing to fight back, and she hopefully will talk a little bit about that. This panel will run a little bit differently. Part of it is the time zone problem. We were not able to work out a time where we could all get together and talk online. The other advantage is, while I met the three of them this morning, they all know each other very well and are not shy about talking and disagreeing with one another. So I'm largely going to turn them loose after I give some opening remarks. What I plan to do is give some opening remarks myself, let each of them speak for about 5 minutes to introduce the areas that they probably feel most comfortable on, and then let them go at it. And I'll only get in the middle to stop a nasty sandbox fight. Kind of a brief history. We've had two major disruptive information technologies in the 20th century. One was television, and I'm old enough to remember the early days I know they weren't color TVs then, they were black and white. Nobody can comprehend that. And most of the time television stations were off the air. But television was sold and touted as, this great innovation that would increase education and opportunity for people to learn. And while it's certainly done that, by 1961, Newton Minow, who was the chair of the FCC at the time, referred to most television programming as a vast wasteland. And I think we can agree today it's got some great things on it. I know that the upcoming program by Ken Burns on the Vietnam War certainly promises to be incredibly educational, but I'm not sure that I would list reality TV and professional wrestling as something that uplifts the soul of mankind. The internet was also sold to us in that way, as a way of better connection, a way of better information, and I think it's probably lived up to its promise a little bit better. There are a number of things it's done. The amount of information that's out there is amazing. I joke that, my wife and I have to argue about things important to our relationship, not over things like where was Abraham Lincoln born or what's the best time to fertilize the dogwood tree in the backyard, because we can Google it. And those fights get settled very quickly. Just the verb Google. Google didn't exist until 1998, and it's already, a part of our language. So it has clearly done a good job, but it's not without its problems. And among the issues that I see in my job are things like threats and incitement. The difference being between them, as I see it, is threats are "I'm going to kill you," and incitement is "somebody ought to kill you." Threats can be personal, and the Alanis case in the Supreme Court, the Facebook threats case, was purely personal. It was against his wife. It was against the FBI agents investigating him. It was directed at local schools. Or there can also be public issue threats that do bring in some serious First Amendment questions. The Turner case out of the Seventh Circuit, where after a panel of the Seventh Circuit decided that the Second Amendment did not apply to the states, Mr. Turner decided to post something on his website that these judges ought to be killed, that the tree of liberty needs to be watered with the blood of tyrants, to quote Thomas Jefferson. Another case I think of is Planned Parenthood versus the ACLA, where an organization that was opposed to abortion was publishing information about doctors and not not too subtly, but not directly encouraging other people to kill them. We also see things like revenge porn and sextortion, and we've had a lot of talk about that in the first panel. I'm not going to bar that from this panel, but I think I'd like to see our panel members talk about some of the other things we see, because they did such a good job on the first panel. Doxing, the getting of other people's personal information and getting it out in public. And then stalking, which could involve threats, doxing, revenge porn, you name it. The Internet makes all this possible for a number of reasons. One is perceived anonymity. And you'll have a panel later on today on real anonymity on the Internet. But a lot of people are under the impression that they are anonymous on the Internet, and even though we can figure out who they are with some investigation, the idea that you're anonymous emboldens people to do things they would never do in a face-to-face connection. Some other technologies that fit with the Internet, cell phones and digital cameras. New York Times had a piece this week on the 10th anniversary of the iPhone and the things it made obsolete, and one of them was cameras. Cameras used to involve film. Film had to be developed, so unless you had your own darkroom, you either took it to the local drugstore or camera shop where it was developed and printed. That limited the number of things you took pictures of, because you didn't want other people seeing sexually explicit pictures or pictures of your abuse of other people. The Polaroid land camera kind of changed that because it made the need for developing irrelevant, but it only made one copy. So a couple, as we heard in the first panel, could take intimate pictures of themselves but not worry about it getting out there. The cell phone and the connection to the Internet just has changed that. I see it in the area of child exploitation, where people now not only sexually exploit children, but they feel they need to brag about it and take pictures of it and then share it with other people. The other thing that we get out of this modern age is location tracking and sharing. I mean, many of you probably share information about where you are so your friends can find you. My son-in-law told me that when he went to college in the mid-'90s, they had to go to 3 or 4 bars to figure out where their friends were, whereas today you can just text one another or check online and find out where people are. And so the ability to track other people has made some of this much more serious. And then there's what I refer to as computer and network insecurity. The Internet was designed as a network for military communications. It was designed for people who this system trusted. And over the course of about 30, 40 years, we opened it up to everybody and never changed its architecture. And so it's a completely open network that relies on us at the other end to figure out whether the person we're talking to is trustworthy. And just because computer systems developed incrementally, they have a lot of flaws. So turning to the bad conduct that we see, what are the limits that the Constitution places on some of these behaviors? What does the First Amendment have to say about this? Professor Citron, let me turn to you first. In a country that believes that speech should be uninhibited, robust, and wide open, what are the limits on free speech, and can we make some of these kinds of criminal behaviors that we're talking about criminal?
So maybe it would be worth starting with a clarification of the kind of speech, words, and images we're talking about, right? So stalkers will often terrorize individuals, right, by threatening violence, by impersonating people, and suggesting they're interested in sex and leaving their home address, right, and by extorting them. Harassers defame, so they cast doubt on people's reputations, accuse them of having sexually transmitting diseases, and then they manipulate search engines to ensure that the defamatory lies are prominent in a search of someone's name. And of course, they invade privacy, which, as the wonderful Ken Blanco emphasized, that invasions of privacy are at the heart of so much of this, right? We expose individuals' nude images, often alongside their home addresses and contact information. And if you think about it, there are lots of ways we can invade privacy, but they're often in very sexually humiliating and demeaning ways. And sometimes people use technology to silence other people. So a distributed denial of service attack, or falsely reporting people's profiles as hate speech, spam, and terrorism to sort of shove them offline. So when I first started working on all of this, say like 10 years ago, the response was to my suggestion that we might be able to bring law to bear against this kind of perfect storm of abuse. The response was, well, it's ones and zeros. It's speech. We can't regulate it. It's the internet, it's special, like hands off. And if we do anything about this kind of speech, we're on a sort of slippery slope to a profoundly worse society. And my response was, well, let's be really careful and thoughtful about what we're talking about. The First Amendment doesn't operate in absolutes. There are certain categories of speech that enjoy either no protection, don't have any First Amendment salience, or has less rigorous protection because it's incredibly harmful and it contributes so little to our sort of social, cultural, and political discourse. And so the kind of perfect storm that I started with is often categories of speech that either has no First Amendment salience or has less rigorous protection. So that includes true threats. And Mike, I look forward, we'll talk about aloneness, which I know you argued for the Third Circuit, and then went on appeal to the Supreme Court. It includes defamation of private individuals about purely private matters. It includes crime facilitating speech, extortion, solicitation, right? And it also includes speech that enjoys less rigorous protection. So in particular, we might understand the publication or disclosure of private communications about purely private matters like nude images, non-consensual pornography, as if it's going to run through the crucible of scrutiny, it'll be intermediate scrutiny because when we're going to talk, Erwin is going to help us work through why it is that non-consensual pornography is the kind of speech that either has no First Amendment salience or we can regulate it. Because in regulating it, we're fostering private speech. And I think crucially, getting people to see this problem as something we can tackle with law required getting buy-in on the idea that harassment and stalking is, as the EFF said in a blog post, which I have to say, folks on the Cyber Civil Rights Initiative, we were like profoundly moved by this post they put up in 2015 to say, cyber stalking and harassment is a digital rights problem, that it's a problem that silences victims and it invades privacy in ways that affects the most vulnerable. And it does so little to advance why we care about speech. And what it does is take people away from public discourse and engagement because they're under assault. So, like, why do we care about speech? One of the many values, we have to speak and listen, right, to engage in self-governance. And if you think about it, right, a rape threat, a nude image, Social Security number, defamation, it contributes so little to political, social, and cultural discourse, and it drives victims away from their engagement. There are studies after studies that show that victims are silenced. They retreat, they shut down their profiles, and they go offline. The marketplace of ideas, right? We think truth will out, we'll have counter speech and conversation, and we should hands off on this kind of speech. But what do we say to a rape threat? Like, don't rape me? A nude image, there's not much of a conversation to be had, right? And it's true that as we think about regulating the harasser's expression, we are impeding their expression, right? But we should be, I think, less concerned about the expressive autonomy of stalkers whose often whole purpose is to silence individuals. So that's, I think, I was going to lay out just like a preview of the kinds of different kinds of speech we're talking about and why First Amendment values aren't at stake. And just one thing I should have started with to say that Britton is a personal heroine of mine, someone I've known for years and years, and who shared with me her own story, was at the heart of my book, and who's a brilliant lawyer, has been an inspiration to me. And of course, I was teasing Erwin that, like, having used his Fed Courts hornbook helped guide me, shape my thinking about constitutional law. And I was so excited when he reviewed my book for the Chronicle of Higher Ed. I think I was like jumping around my house, like doing cartwheels. So it's really wonderful to be on a panel with both of you.
Dean Chemerinsky.
Thank you. Thank
what
you.
are the first problems with regulating this area? When I went to law school, which was hard to believe in before you did, the First Amendment was taught in a way that it sounded like after God had handed down the Ten Commandments to Moses, he said, oh, by the way, and handed him a First Amendment. But when you go back and look at the case law, it pretty much developed within the last 100 years. And it developed for face-to-face speech for the most part. What are the problems with some of the regulation on the Internet, and is the Internet different? And we say that about search and seizure in the Fourth Amendment. Is that also apply to the First Amendment?
It's such an honor to be part of this terrific panel. I'm a staunch advocate of freedom of speech. I spent most of the last couple of weeks trying to argue that all ideas and views can be expressed on a college campus, no matter how offensive, that hate speech is protected by the First Amendment. And yet, I also believe there's no First Amendment limit to stopping, to punishing, to holding liable some of the kinds of things that we're discussing today that occur over the Internet. I do think you've put your finger on the key underlying question. To what extent is the Internet a unique medium of communication? Or to what extent can we use existing laws and First Amendment principles to deal with the Internet? There are ways in which I think the Internet is unquestionably a unique medium of communication, and that has both positive and negative effects. From the positive perspective, it democratizes access to an audience. It used to be to reach a mass audience, you had to be wealthy enough to own a newspaper or get a broadcast license. Now, anybody who has an Internet connection on their cell phone, their personal computer, even the library, can reach a huge audience instantaneously. It very much opens access to information in a way that was never possible before. You give the examples of the debates we have over the kitchen table that can be resolved in an instant. We also have access to a wealth of libraries and museums that otherwise we would never be able to get except for visits that would be unlikely. Also, the Internet is a tremendous benefit in breaking down national boundaries with regard to communication. It is much harder for a totalitarian dictator to cut off access to communication his or her country. In Egypt, one of the first things that the ruler was trying to do in stopping the revolution was cut off Internet access. But people had satellite phones and they could still get access to the Internet. But all of those benefits carry with them the possibility for great costs. It's also possible to much more quickly disseminate harmful information to a mass audience. That's, of course, when we talk about things like cyberstalking or revenge porn. The ability to put something out in front of a mass audience is so different than it ever previously could have been. There's also the ability to put false information out much more. I think the whole discussion of fake news does have a dimension that we've got to confront. Misinformation can be and is put over the Internet. How do we do that? As Danielle has so powerfully written about, there's the problem of harassment and stalking over the Internet that has to be dealt with. And though it's beyond the scope of this panel, there's all of the issues with regard to cybercrime. I recently heard the chief of the Los Angeles Police Department, Charlie Beck, say soon over half of all crime in the United States will be cybercrime. So it's in this context that I focus on your question. The Supreme Court has long said that free speech isn't absolute. Justice Oliver Wendell Holmes said there's no right to falsely shout fire in a crowded theater. The Court has developed categories of unprotected speech, child pornography, which is certainly related to the Internet, incitement that you alluded to, obscenity more generally, false and deceptive advertising. And then you get the areas where the courts have allowed tort liability for speech, like defamation, public disclosure of private facts that are relevant here. I would take all of this that I've said that's fairly abstract and take one specific example, and I'll do so quickly, and that's revenge porn. And I do not believe that the First Amendment prevents the government from having criminal statutes with regard to revenge porn, and it doesn't prevent with regard to civil liability. Let me just say three quick things about this. First, I think it's important to recognize that the term revenge porn is a misnomer. What we're really talking about is the dissemination of sexually explicit information, particularly photographs, without a person's consent. There may be many reasons why somebody does that. Often the reason is revenge, but it doesn't have to be done for revenge in order for it to be something that's intrusive and unacceptable. And I worry that the phrase revenge porn that's come into vogue does distort the discussion. I think we should be focused on any time there's the dissemination of sexually explicit material without consent. That should be impermissible. Is this unique to the Internet? Probably not. The magazines like Hustler magazine in the 1980s had a feature where they would have photographs of women shown, and sometimes it was without consent. That would have been regarded as unacceptable. But I do think the Internet in kind changes the discussion we have to have, because it is possible for somebody very quickly to reach a mass audience by disseminating the sexually explicit material. Second, civil liability exists, but it's likely inadequate. Here I do focus on the torts that I and others have mentioned. There is the tort of public disclosure of private facts. Disclosing sexually explicit material without consent is not newsworthy. It's offensive to the reasonable person, thus meeting the definition for the tort. There is the tort for intentional infliction of emotional distress. I think that many have misread the Supreme Court's decision in Snyder versus Phelps as precluding all First Amendment liability for intentional infliction of emotional distress. I don't think it does that. Snyder versus Phelps, you might remember, involves a church out of Topeka, Kansas, the Westboro Baptist Church, that goes and uses funerals, especially those who died in military service, for expressing a vile anti-gay, anti-lesbian message. They came to Maryland to do this. They were liable for intentional infliction of emotional distress with a $10 million judgment. The Supreme Court 8-1 said that they could not be liable because their speech was protected by the First Amendment. It involved a matter of public concern. It was out in public, so it didn't invade privacy. And I've seen many commentators say, this means there can't be First Amendment liability for intentional infliction of emotional distress. That's not what it says. It says if it's speech that's otherwise protected by the First Amendment, there can't be liability, even if the speech is offensive. So I think there are torts, and there are certainly instances of victims using them. This woman in Texas is successfully sued for revenge porn, got a $500,000 judgment. The most famous example of a judgment, of course, is Hulk Hogan getting a $140 million judgment. And I, like I'm sure the others on the panel, got a lot of calls from the media and said, doesn't this raise great First Amendment concerns? I said, I don't think so. All it establishes is if you put sexually explicit material on the Internet with somebody's consent, it's an invasion of privacy. And that's what the law should be. But, as on the first panel was explained, as Danielle was talking about, victims are so unlikely to bring a civil suit when this happens. Most of all, they want this all to go away. They don't want to bring more attention to it by filing a suit. This kind of revenge porn is disempowering, making it less likely that the victims are going to bring civil suits. Also, it takes effort, often expense, to get a lawyer to bring the action, so it just doesn't happen very often. And that brings my third and final point. That's why I think that criminal statutes are so important in dealing with the problem of revenge porn. We use criminal law to deter wrongdoing. This needs to be deterred. We use criminal law to punish. This is the kind of behavior that warrants punishment. A majority of states now have some form of statute dealing broadly with what's called revenge porn. If you look on the Internet, you'll see varying estimates of the number of states that have this. And I think that just depends on what you count as laws in this area. And the laws vary enormously. They vary with regard to precision. There's always concern about vagueness. This relates to speech. They also vary enormously in terms of punishments. But I think that the consensus would be that the state statutes are too weak, that there really needs to be a federal statute here. Jackie Spira, Congresswoman from my area, now in Northern California, introduced a bill, the Intimate Privacy Protection Act, and I think that it would be desirable to adopt, and this is one of the rare instances where I'm on the opposite side of the ACLU. The ACLU has raised free speech concerns, and I don't think this bill would violate the First Amendment. What it prohibits is the dissemination of sexually explicit material without consent. It defines sexually explicit material as genitals or showing the nipples of a post-pubescent female. It does have exceptions if the material is gained to the public. What we do in public, there's not a privacy interest. If it was done for commercial purposes, it is consensual pornography. There is a public interest exception to this. The example that was mentioned with regard to the public interest exception is, imagine that a male supervisor goes into a woman's office and repeatedly exposes himself, and she uses her camera to take a picture and then uses that picture and turns over to the union to file a grievance. Well, if there wasn't a public interest exception, technically she'd be violating that because it is sexually explicit and it's without consent. But obviously what she's doing there and turning over the information should be protected. I think one of the parts of the bill that's quite important is changing Section 230 of the Communications Decency Act. Section 230 of the Communications Decency Act makes it very difficult when it comes to Internet providers to force them to take down material. It says they're common carriers. I think Section 230 has many benefits in terms of free speech, but this is a place where I think the law needs to be changed. Now, the mens rea under this proposed statute is a recklessness state of mind, which I think is appropriate. The ACLU wants the bill to have an intent to cause harm to the victim, and I disagree with the ACLU, both in terms of whether the First Amendment requires it and whether it's desirable. I don't see anything in the First Amendment that says there has to be an intent to cause harm to the victim. If the material is intentionally or recklessly made publicly available, I think that's sufficient. And I don't think it should just be about intent to cause harm to the victim. Imagine that the person is putting the material online for profit or personal gain. That should be just as objectionable as cause harm to the victim. So I think the overall answer to your question is that we can take existing principles, but we're going to have to tailor them to this new medium, and we are going to need new laws to deal with the problem.
Britton Heller, one of your jobs is dealing with various providers, and one of the panel is billed here as a not just First Amendment, but as free speech. And in the United States, while the origin of our free speech law comes out of the First Amendment, we have an ethos in this country that has this concept of we all have the right to free speech, and it's not just the government that can't stop us, that people should be allowed to do that. So I guess one of the throw out the question is, can we or should we rely on providers to help in this fight? And let me ask, is it a good idea to rely on them? Their motive is profit. And I look at, and some of these companies will be talking this afternoon, but they look at what's happening out in the market and what's affecting their business model. And if it suddenly is having a bad effect, they'll take notice of it. And if it's not, and they won't, so after the last election and certainly after Charlottesville, we have companies now getting concerned about hate speech online. I deal with it from the other side. Most Internet companies were very law enforcement cooperative in giving us information if we gave them the proper process. Then we got the Snowden disclosures, and suddenly they all became protectors of privacy that they weren't quite so motivated about before. So that the profit motive sometimes has an impact on them. Are there legal limits that are doing so? And this talk a little bit about 230. And then with some of the stuff that's going on today, should they be treated as common carriers? Should we having some of these companies shut off access to people that they don't agree with?
Thank you. Can you all hear me? Okay, great. I'm going to start by saying thank you. I feel very honored to be here today as a former member of the Department of Justice who was a chip in my section, who is now surrounded by some of my personal legal heroes. If you had told me 10 years ago, when I was the Jane Doe in one of the first cyber harassment cases, that I would be sitting here today with these people having this conversation, I wouldn't have believed you. So thank you all for being here, and thank you for inviting me. As Michael said, my job as Director of Technology and Society for the Anti-Defamation League is to work with tech companies in situations where civil rights and the internet intersect. The center that I run is the Center for Technology and Society, and we provide consultations and a range of options to engage with these cyber hate-related issues. We conduct original research about online harassment, cyber hate, hate speech, and online extremism. This is all intended to balance freedom of expression-related concerns with public safety-related concerns. And a good example of this, spinning off something that you said, Dean, about the Westboro Baptist Church, is we had an event where we brought together a former member of the Westboro Baptist Church and put her in dialogue with a former ISIS recruiter. And what the two women had in common was that they were able to be convinced through constructive dialogue on the internet that their former lifestyle was wrong, and those were not views that they would advocate anymore. And so today, both of those women speak out and actually use counter-speech methods based on the same ways that they used to recruit and engage people. When I speak at my job, I speak with some authority as a former member of law enforcement and as a former victim of cyber harassment. So when you look at this work, it's very complicated. It's also very interesting because there's both public and private facing efforts within the tech industry. And this encompasses various concerns in law and technology and policy, but you always have to marry that with the technology and the innovation. So to answer one of your questions, to do this effectively, it requires working within a company's business model and their philosophy to achieve the best results. Because oftentimes, when you're working on freedom of expression-related issues and American companies, it's very easy to convince them that they can do good while still doing well. We apply advocacy tools to try to alter the internet ecosystem and create social change. But at the same time, we acknowledge that this is cyber harassment and revenge porn and all these things are a technical problem, but they do not necessarily have a technical solution. Oftentimes, what we think should be done by the companies is something that law and policy can take a better hand in. And an example of this is a study that my center did on the harassment of journalists in the presidential election. Right before the last election, we started hearing from journalists about the fact that they were covering the presidential election and they just couldn't do their job because they were being harassed on Twitter with these deluges of anti-Semitic images, messages, and content. It was pretty extreme. One woman was harassed for 19 hours straight, and then she went out and bought herself a firearm. Another person received a call from a coffin maker asking when the child's coffin should be delivered to their home, which had been ordered in her family's name. Another journalist was very open about having epilepsy and received a video replete with hateful images of Pepe the Frog, which was designed to induce seizures. And he was actually incapacitated for several months after receiving that video. So when we received this information, we thought, well, what do we do with this? And we decided to do the first big data analysis of cyber harassment as it intersected with hate speech. We were able to quantify 2.6 million anti-Semitic tweets in the year-long period leading up to the election. This had a reach of 10 billion with a B accounts. About 20,000 of those were specifically directed towards journalists, with 80% of that targeting 10 people. And when we looked at the 10 people, it was very interesting because they weren't what we expected. They were conservatives and liberals and men and women and bloggers, all the way up to Pulitzer Prize-winning editors of national publications. The only connective thread that we could see was that they all had Jewish last names. So by doing this big data analysis, we were able to show that this was an animus-motivated attack and able to take that information to Twitter. And Twitter responded very well to it. And in response, they looked at their terms of service and really took a good look at that and made it much harder for people to be harassed. Over the last year, you may have noticed Twitter rolling out additional products and services for people on the platform to prevent others from being harassed and to control people's own experiences. They also came to ADL's National Convention about anti-Semitism and talked to a lot of the people who had a deep concern about this. When they reviewed the terms of service violations, they found that about 2,000 accounts were in violation of their terms of service and removed these neo-Nazi-affiliated users from the platform. That whole exercise taught us that through that exercise, I'm trying to illustrate that it's the terms of service that really regulate the relationship between users, consumers, and the law. And a company's obligations are defined by their terms of service, but they differ from contracts. They're not enforceable like contracts. And there's been a change over the last few months in how customers perceive these terms of service. And it's gone from a user of a platform or a service to almost a right to access by customers. And so if you understand what's happening in that paradigm, going from I'm just a user to this is my right to information, you can see why people are starting to mobilize around terms of service. Many terms of service already prohibit hate speech, harassment, all of these things that would be exceptions to the First Amendment. But Charlottesville and the events there have really been a linchpin, and they've moved public attitudes forward in a way that wasn't possible before. Through the actions that tech companies have been taking in response to that, it's very clear that unless terms of service are transparent and companies decide to enforce them, the companies are not that there should be best practices for terms of service to try to get companies to enforce them in a way that meets public policy. So ADL put out best practices for companies in 2014, and these include things like being quickly responsive, providing special consideration for people like journalists or like dissidents who need to be on the internet, having transparency in terms of service processes, having appeals to protect legitimate speech, and to conduct information sharing as permitted by law. Most companies seem concerned about domestic terrorism-related uses of their products and services, and they've moved on to child pornography and other topics like that. And what you're seeing now is the next evolution of that debate as it moves forward to privacy issues, personal safety, and issues like non-consensual pornography and cyber-stalking and cyber-harassment. Many questions that I get are about technology-wise, why can't we do more? And some of these answers aren't legal questions, they're tech questions. So if you look at efforts like Perspective AI, which is a Google filter that's supposed to measure the toxicity of speech, it's just not there yet. The toxicity measure is designed by Google to try to see how many people are pushed off the platform by others' negative speech. So it's very different than the First Amendment-related concerns as most people conceive them. It's very different than looking at hate speech and other things. It's talking about how many people will leave the conversation. So in some aspects that's very useful, but in other aspects it's a very different problem than what most people think about when they look at artificial intelligence and content moderation. I think companies have a heightened awareness of their power, which also reflects their concerns over potential liability and regulation. Certain actions that companies have been taking are tantamount to one step forward and two steps back for researchers and people who work in the online extremism space. This is very tantamount to the whack-a-mole and electronic evidence issues that I encountered as a prosecutor, and now we're seeing that move into other realms. There's increasing pressure on technology companies from impending legislation in the EU, I believe it's also in Russia, Israel, and a few other countries now, about how manifestly illegal hate speech should be regulated, and if it can be regulated at all. And then there's a question about content moderation that intersects with the architecture of the internet. Who should be able to make the decision that something should be taken off the internet? Is it the internet service provider? Is it the server? Is it the host? Is it the moderators? If you look at the recent statement by Cloudflare saying, we were able to kick Daily Stormer off our service, and it's because I woke up and was in a bad mood. And nobody should have that power. So this is kind of a scatter plot of all of the issues that I deal with as they relate to free speech and as they relate to technology. So I look forward to your questions.
That's not a tiring job at all, right?
Well, I've got two kind of broad things I'll throw out to the panel and let you guys go at it. One is Section 230 of the Communications Act. Dean Chemerinsky's referred to it. Professor Citron, you and our panelists from the first panel, Ben Wittes, have written a paper on it that's well worth everyone's reading. So that's topic one. Topic two, and any order you want to take them, dealing with is the internet different? One of the things I've noticed, particularly since I see threats and incitement cases, is the Supreme Court in the area of incitement held that there has to be a danger of imminent violence. And that makes a lot of sense in the face-to-face speech category. Somebody giving a speech to an audience gets audience feedback. They know when they're driving the audience to perhaps go out and commit acts of violence. Somebody can post something on a page on the internet that says somebody ought to kill these judges for their decision in the Second Amendment, and here's where they work, and here are their pictures. Don't know when someone's going to pick that up and go to work on that. So with those two very different ideas, Dean Chemerinsky, why don't you take the lead?
Let me take the latter of the two questions. I think that there is a difference between incitement as an exception to the First Amendment and true threats as an exception to the First Amendment, though there's obviously a relationship between them.
Right, and a lot of the cases tend to move toward deciding things are true threats move that way because of the limitations of incitement. When you read them, you feel like this is really an incitement case, but they're going to make it a threat case because it's easier to do that.
And I think it's a desirable move. I mean, the problem with incitement as a category is that historically it was so loosely defined by the Supreme Court. The first incitement cases were the first real Supreme Court decisions that deal with free speech. Schenck versus United States, Frowork versus United States, Debs versus United States. It's where Justice Holmes articulated the clear and present danger standard. But then you look at what people were actually convicted of doing. It was circulating a leaflet that argued that military conscription violated the 13th Amendment. It was a German language newspaper that was very tame in criticizing the war effort. Abrams went even further and said that people could be punished because they were arguing in a way against the Russian Revolution, in a way that might discourage armaments that could be used in World War I. And then you look at how the incitement test was used during the McCarthy era, and I think that Brandenburg rightly looked at that history and said, we need a much more restrictive test much more speech protective test with regard to incitement. And so Brandenburg says it has to be a substantial likelihood of imminent illegal activity. It has to be directed at causing imminent illegal activity. And I think that's a desirable test. But then there's a separate doctrine under the First Amendment of true threats. And I think that it starts in United States versus Watts, which is a federal statute that makes it a crime to threaten the President of the United States. And the Supreme Court wisely says, well, there's a difference between a true threat and hyperbole. And the court in Virginia v. Black repeats that true threats are not protected by the First Amendment. But the difficulty is that the Supreme Court has never given us a clear definition of what's true threat. Many thought they were going to do so in your case, Alonis, and then they decided it on statutory grounds and didn't reach the First Amendment. My own view is that the circuits that have taken an objective test have used the right approach to this, that there's no First Amendment right to cause a person to reasonably fear for his or her physical safety. That's what the Ninth Circuit says in its en banc decision in the Planned Parenthood case you mentioned. And I think that the Ninth Circuit got it right there. And it does avoid the imminence requirement. And I think it is an appropriate test to use with regard to the Internet. If you reasonably are causing a person to physically fear for his or her physical safety, that shouldn't be speech protected by the First Amendment. Now, I think it's important to limit this to causing a person to fear for his or her physical safety. If we were to ever broaden it and say that causing a person to fear for his or her emotional safety, then you'd undermine so much protection of free speech, because then almost any offensive speech could be regulated. So I think it has to be to physical safety. And I hope the Supreme Court will take another case and adopt that standard. I worry, though, that the Alonis case may indicate a court that isn't inclined to go in that direction.
The facts in Alonis, though, are pretty bad threats. I mean, she gets a Protection from Abuse Act order, for example. He's in the courtroom, and the next thing he posts on Facebook is, fold up your PFA and put it in your pocket. Can it stop a bullet?
And yet the court, I mean, depending on how you want to count Justice Thomas, it's 8-1.
Yeah.
To reverse the Third Circuit and overturn the conviction on statutory grounds entirely.
Yeah, up to that point, and something as I taught threats I began to wonder about was it's the only federal crime I knew about that didn't have a requirement that looked on the state of mind of the actor. It looked on the impact. You know, what would a reasonable person hearing this think, or what would an actor think, reasonable actor think, not what would this actor think? And so it kind of put threats back into the rest of criminal law. Professor Citron, you're...
Okay, so I'll take the 230 question. But first, I think worth noting, and why I think the objective inquiry is absolutely right as a matter of First Amendment law, because the reason why we say threats are prescribable is because they change how people live their lives, right? It hijacks people's their autonomy. And it then, in the case, let's say, of a president, it's sort of the arm of the Secret Service. It changes their behavior. And whether there was an intentionality is a different question than the kinds of harms that we're thinking about when we are prescribing true threats. It's because it hijacks people's lives and the way people behave. It, of course, may augur actual violence, physical violence, but it is all-consuming for people who are targeted with threats. So now Section 230, I feel like I've been a proud radical about how I view Section 230. So many people look at it as sacrosanct. Of course, you may say, well, what are we talking about? Section 230 is a part of the Communications Decency Act. It's a law passed in 1996 that basically tried to regulate porn on the internet. The statute itself, note the decency part of the statute. And most of the Decency Act is struck down in a wonderful Supreme Court case, ACLU versus Reno. And the remaining, the shards of what's left of the Decency Act is Section 230, which is called Good Samaritan Protection for blocking offensive content. And what it was trying to do was incentivize providers to remove offensive, and these are the words of the statute, offensive content. Filter or block offensive content. And the statute itself in its title talks about creating an immunity for good Samaritans. And how this statute's been interpreted is incredibly broad, so that not only good Samaritans, like we might say Twitter and Facebook, engaged in the project of trying to help people and not maybe getting it right at scale, under or over blocking, but the very worst actors, bad Samaritans, revenge pornographers, who traffic in illegal activity, they too get to proudly say, I'm immune from liability, too bad, so sad. So when victims come to them and ask them to take down destructive, arguably illegal content, they get to say, I can have a whole business model around smut, extortion, human trafficking. They can say, look, it's not my content, it's somebody else's. So Ben Wittes and I, who Ben spoke on the previous panel, have offered language that we might fix Section 230. We've got some proposals now on the Senate side that have to do with sex traffickers and Backpage. I think we should change Section 230 to say it's really only the Good Samaritans, right, who are actors trying to address and prevent illegal activity and taking reasonable steps to do so. They absolutely should enjoy immunity. They should be, right, if they take reasonable steps, they may not have to do, they can be under and over inclusive, but if they try, right, and they can earn that Good Samaritan status, we should take the drafters of the Decency Act at their word, and sites should not be able to enjoy immunity when their entire business model is basically ruining people's lives.
What do you do with the intermediate situation, the site that doesn't necessarily go out to encourage it, but ends up being a place where it is, that's the kind of traffic that shows up there? What would you require for some kind of liability? Actual knowledge, recklessness, as the dean has suggested. The Supreme Court in Garrison versus Louisiana, which was a criminal libel case, the district attorney of New Orleans went in to do what district attorneys periodically do, which is they attack the judges when things aren't going well. So you accuse the judges of being lazy and incompetent, and the judges, as judges tend to do, get upset. And they had a prosecution brought against him for criminal libel. And the Supreme Court gave him the same protection that they had given in New York Times versus Sullivan, which was reckless disregard for the truth, so that recklessness at least meets the constitutional standard. Would you feel that's enough, or do they need to actually know? I mean, obviously the company that says, send us your revenge porn pictures knows what they're getting, but...
I think, and it's a great question, I think it's really important to see there are actually two steps here, two questions. Section 230 is a policy layer over the First Amendment. And so the question of the immunity question is whether or not you've taken reasonable steps to protect or address illegal content. Without that immunity, you aren't strictly liable for content that you host. All of the protections that the First Amendment brings, you need a theory of liability against a provider, and that theory has to be constitutional, right, as applied. So the wonderful question you asked, Mike, whether for criminal defamation, right, they would enjoy all the protections of Louisiana versus Garrison, right? Recklessness. You'd have to have a theory of liability, and that theory, as applied, would have to be constitutional. So does that make sense? It's a two-step process.
I have 2 points. One is that it's very important to remember that if you have speech on platforms, when people say, a lot of people come and they say platforms should do something about this because of the First Amendment. Well, because of Section 230, the First Amendment governs sorry, I'm a little jet lagged today. The First Amendment covers government speech, and many of the contents that people are very upset about are governed by the terms of service on these platforms. You really can't bring a First Amendment-based challenge based on a lot of the things that really upset people that they would love to try to respond to on the internet. I think the second is to think about the architecture of the internet, and if that makes this speech different. I know we talked about this constitutionally before, but I'm talking about when you're looking at the specific question of incitement or true threats. Many of the people who come to us for assistance are in situations that haven't been contemplated yet by the courts. I guess a personal example is earlier this year I was featured in something called the Skype directory. And if you recall, there was a story about how refugees were being called Skittles online to get around filters that were supposed to catch hate speech. And so people got upset about that. And in some of these corners of the internet, they decided that they were going to start using pseudonyms for different ethnic groups to try to mess up Google's Perspective AI project. So Skittles for refugees, Jewish people became Skypes, African American people became Googles. Substitute in other racial epithets as necessary. So the Skype directory was actually a listing in overwhelmingly positive speech, but with a wink and a nudge. So it was a hit list for Jewish people. I was actually featured after Albert Einstein, and I didn't have the heart to tell the trolls that was more flattering than anything else. But it was designed to make a list for the community so they could know who to target. If you just looked at it facially, it was, Britton Heller is a prominent scholar. Britton Heller is a prominent legal activist. Let's show her some love and show her how we feel, along with links to my personal information. So looking at the way that people engage with internet speech, where if you look at, a lot of people say it's edgy. And this is what humor on the internet does and memes do. They actually mediate the difference between what is socially acceptable speech and what is circumspect. That's not a legal process, that's actually a sociological process. And so I think it's going to be interesting when you look at when issues of cyber harassment and cyberbullying and true threats and intent start to intersect with internet culture. The second part of that is looking at cyber mobs and seeing if that shifts the needle. If you look at the circumstances surrounding the massacre in Charlottesville, we now know that they used online channels not just to communicate, not just to spread their message, but to mobilize and to actually talk about how they were going to commit mass violence in the demonstrations. We have other situations like in Whitefish, Montana, where there was a group of Richard Spencer's followers who decided that that there had been a personal slight and that they were going to target the Jewish community in the town, and did a remarkable job terrorizing those people. They were able to mobilize people all around the country, and that wouldn't have been possible before the internet. So when we think about constitutional speech, I always think that the courts lag behind in their consideration of how technology works. And the people who are on the forefront of that are actually the people who are trying to misuse the technology, abuse others, or harm. So I say that the pace of innovation is greatest for hate, which is rather unfortunate.
Let me go back to you mentioned Cloudflare, and just for way of background, Cloudflare decided one day that Cloudflare is a company that provides protection against distributed denial of service attacks, which are ways of taking websites offline. And recently they decided they didn't want to do business with the Daily Stormer anymore, which is a neo-Nazi online site. And the end result is they're offline, because if you don't have Cloudflare, you're not on the internet. Suppose that the internet existed in the 1950s, and the NAACP wanted to have a website, and Cloudflare was based in Atlanta, Georgia, and decided it wasn't a good idea for business for them to provide protection for the NAACP. When we change the paradigm, what does that tell us about these big organizations on the internet, should they be common carriers or public utilities, even when what they carry is stuff, or what they help is stuff that we may not like?
Yes. Your example is powerful. What I thought you were about to say is, imagine it was the 1950s and they said that they wouldn't put up anything that was perceived as advocating for communism, and that they took down all sorts of things that today we would regard as mild. They took down a copy of Marx and Engels, the Communist Manifesto, or any kind of speech like that. So I think it's really important that we do treat them as common carriers, and that there is an obligation, but that doesn't mean it has to be an absolute one. And I think we can use existing exceptions to the First Amendment to say, but no, this goes too far. And therefore I do draw a distinction between true threats or incitement or child pornography that are speech not protected by the First Amendment versus expressions of hate, and that is protected by the First Amendment, however distasteful it may be.
Britton?
Yeah. I don't think there's an easy answer to this one. There are so many levels of the internet, and if you look at Cloudflare's terms of service, if you were to hold them to the terms of service, if it was applicable like a contract, then they probably shouldn't have been hosting a service like the Daily Stormer in the first place. That says, and going back to some of my earlier comments, the fact that Daily Stormer has been bouncing around and around. For a while, they were at a .ru. After that, they were at a Russian server. Eventually, they were at a .wang. I don't even know what a .wang is, but I was sure they were going to find a host, and they haven't. So perhaps the moral of the story of Cloudflare is that you can push companies to take action. You can try to persuade them, but ultimately it's the responsibility of citizens within a democracy to make their voices known. And so Cloudflare took this action because it felt compelled by public pressure. It wasn't anything legal. It wasn't anything, within the company, policy-wise. It was more the commercial pressure that came to bear on them, and that the CEO had the ability to do it. So I think that when you look at free speech as a way to enforce democratic action and really promote public debate, that's what you're going to see as being more effective than trying to push the architecture of the internet to regulate these spaces.
Professor Citron, any thoughts?
Yeah, no. So I think what is so troubling about all of this is because Cloudflare is almost an indispensable service to keep a site online because it protects against DDoS attacks. And so because it is so powerful, it resembles or is tantamount to the kinds of power that government has. And as Erwin was arguing, we ought to really think about it in that way, that it's providing an indispensable service, and we ought to regulate it and treat it as such, given the power that it has, versus the Twitter, the Facebook, you can go somewhere else. I mean, the one lesson I think we know is that I think they're on the dark web, Daily Stormer, and in encrypted apps. So there is a way, but I think it does trouble all of us because they're so powerful.
Right. It is harder to find things on the dark web. You just don't Google them and get there.
You can't find.
You've got to know how to get there.
I believe it's being hosted by dial-up connections by individual servers. So dark web, dark ages of the internet, you choose.
Let me give each of you about a minute or two to kind of wrap up, and then what I want to do is open it up to the floor for questions and give the audience about 5-10 minutes to ask questions and let the panel respond to them. So if you have any kind of closing thoughts on any of the topics we've talked about, let's start at the far end, and let's start it this way. Britton, why don't you go first?
Sure. I'm going to take the opportunity to bring up one last point that I don't believe has been touched upon yet, but is actually very important in this debate. I believe that the challenges faced by platforms in this space are real. And if we don't acknowledge that, then we're not going to be able to forge effective solutions to problems like cyber harassment and non-consensual pornography. A lot of people, when they come and argue with me about this, they'll tell me they just need to put their best people on it.
Is that what you hear?
That's what I hear.
Wow.
And I have to tell you that the best people are on it.
Yeah.
It's just that these systems are highly complex and vulnerable, because even if you look at the founding of the CDA, back in 1996, there was everybody signed online with America Online or Prodigy or AOL, and they had a verifiable billing address and credit card information linked back to their account. And this was for, I know there are exceptions with the intelligence uses of the internet, but this is how most people got on the internet. And so you look at that paradigm 25 years ago, and now you bring it forward to today, and you can start to see how the way that the internet is still governed under the law is not the way that the internet exists in its modern form. I think there's a lack of general understanding about systems and capabilities. The companies really have to balance between speed and accuracy, and there's a staggering amount of content. 400 copies of Gone with the Wind are uploaded every minute to YouTube, the equivalent weight. And you can't expect human reviewers, right now most of it is human review, to be able to reasonably catch all of that. I think there's actually two different problems when you're looking at content moderation. One is, do these things make it onto the platform? And the second is, if they make it onto the platform, are they maintained on the platform? And these are the ways that we should grapple with the First Amendment issues through those two separate paradigms. They're very different. And let's see. And the last point is that when you're looking at issues like hate speech, which are a little different than what we've been talking about today, it's very important to remember that the contextual nature of certain types of speech can also prove to be another challenge. There's a big lack of consensus on definitions and on whether or not these things should be allowed. Because it's not First Amendment restricted on platforms, you can make decisions like that you can't in other forums. So apart from the question of whether or not the First Amendment governs, is this something that we socially want to promote, or that we want these structures that are integral parts of our modern lives to reflect? I don't have answers for you, but I'm happy to engage in debate.
Professor Citron?
So what I am finding gratifying is that we no longer talk about the internet, like let's use quotes, right, capital I, like it's some special ethereal thing out there where we can all be town criers and engage in public discourse, and that's all we do. It is one of the exceptional things we can do with network tools, but we know we use network tools to work, to engage with other people, to get jobs, right? It's crucial to all of our life opportunities. And I think viewing it as textured and contextual and complicated, it's, of course, then becomes ever complicated how we address it. But bringing the fullness of an understanding of what we're wrestling with is a gratifying move, I think, for all of us.
Dean, you get the Dean's prerogative of going last, and then we'll open it up for questions.
What we haven't talked about it much is the Supreme Court's attitude towards free speech over the internet. Because whenever we want to discuss what kind of government regulation there should be, ultimately it's what's the Supreme Court going to do. And so I'm surprised that none of us has mentioned a Supreme Court decision from June of this year, Packingham versus North Carolina. And if you haven't read it, you should focus on the beginning of Justice Kennedy's majority opinion, where he discusses in great detail why he regards the internet as a unique medium for communication. Packingham versus North Carolina involves a North Carolina law that prohibits those who are registered sex offenders from being able to go on to interactive social media where minors might be present. Lester Packingham, when he was 21, had been convicted of taking sexual liberties with a minor. He was a registered sex offender. He got a traffic ticket. He got the traffic court judge to quash the ticket. He then went on his Facebook page and posted, "God is good." For that, he was indicted and convicted. Many others in North Carolina have been convicted of violating the statute for this. And the Supreme Court unanimously declares the law unconstitutional. Justice Kennedy writes the majority opinion, drawn by Justice Ginsburg, Breyer, Snyder, and Kagan. And he begins by saying, in order for speech to occur, there has to be a place, and the Internet is a unique medium for communication. He describes how over 70% of Americans are on some social media. He says there's more people on the Facebook worldwide than the entire population of North America. And then he concludes by saying that, therefore, any government regulation of speech over the Internet has to be subjected to the most exacting scrutiny. Justice Alito writes an opinion concurring in the judgment drawn by Chief Justice Roberts of St. Thomas, criticizing the loose language in Justice Kennedy's opinion, essentially saying we don't need this ode to the Internet. But I do think that
and like starry-eyed, no? I guess my comments were a critique, I think, of the majority.
But I think what's important is for any discussion we want to have about how can the government regulate speech on the Internet, it's going to be coming before a court that I think is going to presumptively use something close to strict scrutiny when the government tries to regulate speech over this medium.
Okay, we have microphones up front. I realize that most people move to the back because that's what you do in law school, but you've got some amazing experts up here to ask questions of. We've covered a lot of stuff. So let me open it up. Please come forward.
I'm wondering whether a lot of this conversation is about a train that's left the station. And that is, I sort of started keeping count of how many times the word speech was used in a way it would not have been used in the 17th, 18th, and 19th centuries. So, for example, private speech. Speech is inherently public. You can practice for a speech in your bathroom. You can't give one. Hate speech, speech has a certain persuasive content. Hate speech is not speech. And in using the word speech in a 21st century way, have you inadvertently converted, say, when we talk about the cruel and unusual punishment clause, we ask, is it cruel and unusual punishment? But now the conversation seems to be, what forms of cruel and unusual punishment are cruel and unusual? And whether, in fact, there's a language that you've been trapped in.
Okay, can I jump in just to say that Dean Chemerinsky has to go catch a flight, and I'm getting nervous, so I think someone who's supposedly helping run the symposium, you should answer Mark's question, and we love you, and then we're going to send you to the airport so you may get to give your amazing speech tonight at William & Mary.
I'm embarrassed. I think the problem with the way you phrase the question is that the conception of what the First Amendment protects has dramatically changed, especially over the last several decades. As I alluded to, and as you know so well, the first Supreme Court cases to really deal with the First Amendment weren't until 1919. The First Amendment wasn't applied to the states. I think it was 1925 in Gitlow. So we can argue over whether it was Gitlow or whether it comes a little bit later. But basically, we're just saying for the first century plus of American history, the First Amendment wasn't protected by the courts. In the initial Supreme Court cases, I tried to allude to very quickly, with regard to speech, were not speech protective at all. But I think that something has happened in recent decades that has changed the court's attitude with regard to speech. The court has come to take a very deregulatory aspect with regard to speech and done so across a wide array of different kinds of expression. And so I think we have to talk about speech over the Internet in the context of today's First Amendment jurisprudence, not the jurisprudence that there would have been in 1950 or 1900. And I have to do what Danielle tells me, so I'll excuse myself, but I'm able to answer.
No, thank you.
Right?
Should just wrap it up.
Oh, yeah, I'll wrap it up. Yeah.
Do we have any other questions? We do have one. Okay. You'll have to do without the dean.
When we talk about constitutional protections, we're talking about U.S. citizens and U.S. territory for the most part. Internet doesn't recognize U.S. So how much of this problem is outside of our control, and how much of it will be even more outside our control as time goes by?
I think we're going to address this in later panels when we talk about the proposed EU legislation to regulate manifestly illegal hate speech within their countries. It's a very contentious issue, and I've spent a lot of time in Brussels this year because of it. There are attitudes that I've heard from people that there's an almost colonial feel to the way that these companies are all American and they're pushing First Amendment jurisprudence on us. And in our national jurisdictions, the First Amendment is unique to the United States, and in other contexts, hate speech is illegal and other types of incitement or threats. But I'm sorry, I just lost my train of thought.
But I think really smart to bring up the EU, because they're going to be, they are driving a lot of these conversations in companies in ways that
Thank you.
concern us.
It's back now.
We're one mind. We're good. Yeah. Right?
Yeah. So the EU regulation may actually have an impact upon speech in the U.S. because the fines for allowing this manifestly illegal hate speech, 30 million euros, which may provoke American-based internet companies with American-based jurisdiction to over-regulate speech based on the very high regulatory fines.